Hello everyone, Lakshita here. Today, me and my friends Dimple, Swati, and Ankit are here to discuss with you the topic of jurisdiction of Supreme Court. First of all, jurisdiction means having a legal right over something. A court have jurisdiction over a legal question. After that, Article 124 of the Constitution provides for the establishment of the Supreme Court. The Supreme Court of India is the court of final appeal and the highest constitutional court. In order to enable it to perform its sacred duties, it has been conferred with very wide jurisdiction as they are original, appellate, advisory, writ, review, and the last one is the Article 136, the inherent jurisdiction. It is also known as SLP. So further we are here.
Supreme Court is one of the most powerful courts anywhere in the world, which functions with the limitations imposed by the Constitution. As India is a federal country, legal disputes are bound to arise between the Union and the states and among the states themselves. Article 131. Original jurisdiction has the power to resolve such cases with interest to the Supreme Court. These are those cases which are directly considered by the Supreme Court. Now the question comes, why original jurisdiction? Because no other court rather than Supreme Court alone has the power to deal with such cases. Supreme Court not just settles dispute, but it also interprets the powers of Union and the state government as laid down in the Constitution. In the case of West Bengal government has filed a case with regard to the rights in mines in coal-bearing areas against law under Article 131. This was the first suit under the original jurisdiction of Supreme Court. However, this case was dismissed, upholding the validity of Central Act. Court of Last Resort, Article 132, which provides for the appellate jurisdiction of the Supreme Court in appeals from the High Courts in certain cases. In simple terms, a person can appeal from the Supreme Court against the decisions of the High Court. Appellate jurisdiction tries appeals from the lower courts under Article 131 under Article 132 in constitutional cases, and under Article 133 in civil cases, and under Article 134 in criminal cases. In the case of Sitaram and others versus State of UP 1979, it was observed that an elaborate judgment of the High Court, it found the case of the prosecution proved, although it confirmed the acquittal of quite a few. The accused were 12 in number and were awarded life imprisonment. Thereupon, this convicted appellant preferred appeal from the Supreme Court.
The third type of jurisdiction vested with the Supreme Court is the advisory jurisdiction under Article 143 of the Constitution. This jurisdiction vests the power with the Supreme Court to advise President on any matter of public importance or on any question of law. However, it is the discretion of the Supreme Court whether to answer such questions or not. If the questions raised are political in nature, or if it can undermine the security of a state, then the court may choose not to answer such questions. Moreover, it is upon the President whether to follow or not to follow these opinions and advices. So far, 12 references has been made under this article, and the very first reference under Article 143 has been made in the famous Delhi Laws Act case. Yet another type of jurisdiction vested with the Supreme Court is under Article 136, that is special leave to appeal, which gives the court the power to special leave to appeal from any judgment, decree or order from any court or tribunal across the territory of India. And this is a very wide and discretionary power. This is a very extraordinary power, and that's why the court has reiterated again and again the fact that this power should be used only in exceptional circumstances such as grave miscarriage of justice or an apparent error of law. Only in such exceptional circumstances the power under Article 136 can be invoked, and this has been held by the court in the case of Durga Shankar Mehta versus Thakur Raghuraj Singh, 1954 AIR 520. And the last type of jurisdiction vested with the court is the review jurisdiction under Article 137 of the Indian Constitution, and this particular jurisdiction vests the power with the Supreme Court to review its own judgments and orders, and this jurisdiction can be invoked by the court if there is any error of law or any error of law that the court has made in its earlier decisions, or if new material evidence has arisen in that particular case. In such circumstances, review jurisdiction can be used, and within 30 days of that particular judgment or order, a review petition has to be filed, and it has to be placed before the same judge or the same bench which has decided the case earlier.
Hi, I am Ankit. I conclude this topic. We aware this fact Supreme Court is guardian of our constitution. If constitution does not provide this jurisdiction to the Supreme Court, then Supreme Court unable to protect our constitution. These jurisdictions are so important for deliver justice. If Supreme Court have not read jurisdiction, then Supreme Court unable to protect our fundamental right. If Supreme Court have not original jurisdiction, then Supreme Court unable to resolve dispute between center and state. So jurisdiction power is so necessary for protect our constitution. Thank you.